In this session, we're going to continue our discussion on contracts. This is part 2 of the discussion. If you've not watched the first video, you need to go back and watch it, as this video will build upon the principles that we talked about in the first video. So we've talked about what it takes to make a contract now. In our example of the painter and the homeowner, we have the easy example that they go through of there's a meeting of the minds. They both understand that there's an offer of painting the house in exchange for $2,000. There's an acceptance of it. So there's a meeting of the minds. There's consideration through service of painting and money payment for those services. Um, there's capacity in both of them. They're both of age. There's no mental incapacity there. And then um, contracting to paint a home is perfectly legal. It's not against public policy. So we have a valid and binding contract. Well, now can the parties decide to amend the contract? Now the painter has decided, the homeowner has now decided that instead of just painting the inside, he now wants to paint the outside of his home too. And so he's offered an additional $2,000 to paint the outside as well. Well, the parties may agree to modify the contract. So their contract of painting the inside for $2,000 may be modified to paint the inside and the outside for $4,000. So to be valid, the modification again has to have a meeting of the minds. There's got to be an agreement to the modification, the terms. The modification, just like with creating the contract, it can be orally, it could be written, it could also be implied by conduct. So if the modification could show up in that the offer or the homeowner tells them, hey, I want to paint this, I'll pay you an extra $2,000 to paint the outside. And then the homeowner goes to work one day, they arrive home, and when they come home at lunch or after the day, they notice that the painter's outside with his workers and they're painting the outside of the house. Well, obviously, the conduct of starting to paint the outside of the house would be evidence of the contract modification to include painting the outside of the house for an extra $2,000. So we've talked about these requirements and what it takes to create a valid binding contract. There are circumstances, however, where a court may find that despite the appearance of all four elements being there to create a valid and binding contract, there was no true meeting of the minds. So it may be apparent that there was an agreement based on an individual analysis of the four requirements, but there are certain circumstances that are present that indicate that the parties have not truly agreed to the terms, to the essential terms, and as a result, there is no contract. So we've got 3 instances here in which there's no true meeting of the minds. One is fraud, next is duress, and last, mistake of fact. We'll now look at each of those briefly. So fraud. A contract that's procured under circumstances of fraud is voidable. You have fraud in fact, which is where the contract is made based on an untrue statement about a material fact. In other words, it's a misrepresentation. And it's a misrepresentation to the extent that the person does not understand the essential terms of the contract. The good example that's given in the book is the person signs a deed of trust to transfer property when the person is told that it's an employment agreement. So clearly, there is a fraud that's being perpetuated upon the person who's signing the deed of trust. He thinks he's signing an employment agreement, believes he's going to work for the person or company, but instead he transferred his property. Obviously, under those circumstances, the contract should be deemed procured under circumstances of fraud and would be void. Fraud in the inducement is similar, but it's where a party makes a false statement to entice the person to enter into the agreement. Again, the book gave a really good example where a jeweler calls a person or tells a person that the ring is a diamond ring when in fact it's a zirconium. In that instance, the person has the option to cancel the contract. But for them to have that option to cancel the contract under either theory of fraud, the misrepresentation must be material and it must be relied upon by the person in deciding to make the contract. So in the jeweler instance here, since it's right here, let's take it. The misrepresentation is clearly material, because if you're buying a diamond ring, why are you buying it? You're buying it because of the diamond. And the fact that it's not a diamond but a zirconium is a material term. And then obviously the person is relying upon the representation that it is a diamond when they're deciding to make the purchase agreement. So in fraud, though, you've got to remember that the concept of puffing. We'll talk about that more in sales, but puffing is where you are trying to bolster or sell something. It goes back to the like an example of if you're selling a car salesman may tell you this is the fastest car on the lot. This is, one of the nicest cars on the road. That's mere puffery. They're trying to sell you on some opinion about the car, but it's not any real guarantee. So you got to distinguish fraudulent misrepresentations from puffing. So you have promissory fraud as well. Promissory fraud can occur where a party promises that they're going to perform some act knowing that they have no intention of completing the act. So if our example of the home owner and the painter, if the homeowner promises to pay $2,000 to the painter once he finishes painting the house, and the homeowner knows that they're not going to pay that $2,000 once the home is done being painted, then the homeowner is committing promissory fraud. So in that instance, the contract is not invalidated, but rather the painter would have a claim for breach of contract after the homeowner fails to pay the $2,000. So duress, this is the next example or next form in which you may not have a true meeting of the minds. So duress is when a party is forced to execute the contract. It's usually done out of fear through threats or physical threat. It may be extortion or blackmail, but this is where there's no true meeting of the minds because you're only agreeing to the contract because of fear or threat. So in this instance, the contract is voidable, and the threat needs to be wrongful or illegal. So the third type is a mistake of fact. If the mistake of fact happens, the contract's voidable. So if there's a mistake of fact, then there's no true meeting of the minds. Generally, a unilateral mistake by one party does not make the contract voidable. The exception to that is when the mistaken party made an unintentional mistake in preparing the offer, such that the offer was really too good to be true. So if the offer was just at like a ridiculously low price of, like let's go back to that example of that we talked about earlier of I'll sell my car for $30. If that was the offer that was made, the unintentional mistake may be that they had a typographical error, and instead of it being $30,000 like it was supposed to be, it came as $30. In that scenario, the mistaken party's unintentional mistake when they prepared the offer would be an exception to this, and the contract would be voidable. So to determine if there's a mistake of facts, you consider three factors. The substantiality of the mistake. So when the mistake has a material effect on the party, then it's more likely that the contract will be void. So that means it's a substantial mistake. You got to look at whether the risks were allocated. If a party agrees to a risk, then he's bound by the consequences if the risk occurs. But on the other hand, if there's no agreement, the court will determine which party should be allocated the risk, which party should bear it. Timing, in that sense, you always look for prompt notice of the alleged mistake. Ambiguity. The book lists the ambiguity as another instance in which there may not be a true meeting of the minds. I don't agree with that characterization because an ambiguity does not invalidate the contract. Rather, an ambiguity just means that you've got to do some thinking about how a term or provision should be interpreted or construed. What is the true meaning of the clause, the provision, the word, whatever term or clause or phrase is deemed to be ambiguous. So the examples we've been talking about, mistake of fact, arrest, fraud, all of those make the contract voidable, can invalidate the contract. Maybe in limited jurisdictions, an ambiguity would invalidate the contract, but it doesn't in a majority of them. And that's why I don't list it as a true instance or a true example of where there may not be a true meeting of the minds. I understand their perspective on it, but I think it's different in the sense that it's not a lack of genuineness in the meeting of the minds such that the contract is deemed invalidated. Rather, it just means that the courts will have to look at parties' intentions outside of the written document to determine what the term is meant to mean. So just like I'm saying, an ambiguity just means that a court must interpret the contractual provision or terms to determine what the party's obligations are. So an ambiguity, when does that exist? What is it? Well, an ambiguity is when the term is subject to two or more reasonable interpretations. So a clause could reasonably mean different things. And when the clause or term could reasonably mean different things, then you have ambiguity. It's important to note, though, that ambiguity doesn't exist just because the two parties each proffer a different interpretation of that term or clause. So if the painter and the homeowner each interpret the provision of their contract differently, that doesn't mean that the provision is ambiguous, because just their differences, because that's what always happens, is the parties always disagree over the critical term of their dispute. That doesn't mean that that term, though, is ambiguous. There are a lot of times where courts look at a term and decide, well, you both interpret it differently, but it really doesn't mean two different reasonable interpretations. There's only one reasonable interpretation. And so a lot of times, just because there's a dispute and two people have different views in the contract doesn't mean that an ambiguity exists. Generally, in contract interpretation, courts are confined to the four corners of the contract. By that, I mean that the court, when they're trying to determine what the obligations and duties of each party are under the contract, they only look at what's in the contract. They don't look at what the parties talked about or any of their written communications about offers and counteroffers and all of that. Rather, they're confined to the four corners of the agreement. That is an important thing, in that it's a good point to think of if you're ever in the situation of drafting contracts, is you need to try to be specific and clear in your agreements, because you don't want there to be ambiguity in it. If you are worried about what does this mean, or does this convey what we are agreeing upon, it needs to be in the written document, because the parties' unexpressed intents are not going to be permitted in a contract. I've got breach of contract case that's going on right now. It's over a home construction loan, and the terms of the agreement, it's talking about when advances would be made under the construction contract. The language is that a dispersal will be made, quote, upon borrower request and lender approval, end quote. And so the the bank made a payment because the construction contract set forth completion stages. So if a certain amount of work was done, then they were to make a payment. And the builder reached one of those stages, and he came in and requested a payment. The bank went, they confirmed that the work that was required for that completion stage had been completed, and they agreed, and they made a disbursement. Before they went to before the builder came to the home or to the bank to get money for the home, he told the buyer that he was going to go to the bank and request the second payment, and she didn't have any objection to it. But now she sued our client, and she contends that the language per borrower request and lender approval required that the bank have her approval or permission before they made a payment. And quite frankly, her argument is when the bank talked, that's what they talked about doing is them getting her permission. And there's some favorable deposition testimony to that effect. But when we got into the case, the judge has ruled that the term per borrower request doesn't mean borrower approval. The only person that has to approve it is the lender. And so that's an example of an instance in which there's no ambiguity, and the court is confined to the four corners of the document of the loan agreement. But the borrower is arguing that they should look beyond that and look at what the parties intended to express based on what she was told and what their discussions were. But you don't get to that because you're confined to the four corners of the contract because there was no ambiguity in that contract. Borrower request is clear. It means that the borrower, or in our instance, the borrower's agent, requests a payment, and then the lender approve the payment. And that's what happened in our instance, and no breach of contract by our bank. So the rules of construction is that ambiguous language is construed against the party who drafted it. So in our example of the bank drafted the promissory note. So if that term was found to be ambiguous, then it would be construed against the bank since they were the one who drafted it. Meaning that they would have probably gone with the interpretation of the borrower, and that the term of the note required that the bank get her permission before they made a dispersal. So we talked about if there is a ambiguous term or something that the courts may look to the statements of the parties, what they said, what they exchanged in writing. Well, that's parole evidence. Parole evidence refers to all those prior communications or statements that they have when they were forming the contracts. The emails, the text messages, what they'll say was said, all of that would be parole evidence. And if the contract is ambiguous, then the parole evidence could be used by the court, considered in helping them interpret the ambiguous term. It helps you to find out what were the parties' intentions, even because the contract didn't express those intentions clearly. But on the other hand, if the contract is unambiguous, that means the term is not subject to more than one reasonable interpretation, then parole evidence is inadmissible because the interpretation is confined to the four corners of the document. So if the term is not ambiguous, then the terms of the contract controls, and you do not consider any of the prior contemporaneous statements, emails, text messages that were done during the process of executing the contract. Um, Unconscionability. This is a doctrine that comes up when we're talking about terms. Um, it's contractual terms that are too strict or too harsh or too unfair, and they're so harsh or unfair that it, quote, shocks the court's conscience, close quote. That means it's just a very appalling term to the contract. There's a good quote in the book that from a case. It's no honest man in his senses and not under delusion would make on one hand, and as no honest and fair man would accept on the other. So it's an agreement that an honest, an objective, reasonable person, they would not make the offer, and then the other person, reasonable, objective standard, would not accept that offer. That's a good way of defining an unconscionable term. A fair, reasonable person wouldn't make that offer, nor would a fair, reasonable person accept that offer. So unconscionability is often rare in the business setting, especially because most of the time the people that are negotiating things are sophisticated people. Businesses, you have executives that are uh, negotiating these contracts. They're sophisticated people, and there's sophisticated people on both sides of the contract. Business working with another business, and so it's unlikely that courts will find a term to be unconscionable. So unconscionability usually comes up the most in these contracts that are not at arm's length. We talked about the usury statutes, for example. Those are very one-sided. You have the big company that has created this form. It's their standard stuff. It's definitely boilerplate language that's slanted in their favor. By boilerplate, we mean it's standard, pre-written, pre-typed terms that are favorable to the party that's offering it, and it's contracts that will contain terms that you or I would not think to include, and that are highly against our best interest. So, but in the instance of these contracts with these loan companies and people, you could have some provisions that would maybe shock the conscience of the court. An example could be the interest rate. You could get one of these where they charge, like we said, they may not know the usury statute that's in effect because they've got a bunch of these contracts for a bunch of different places, or the usury interest rate may change. And they haven't realized it yet. But you could have one that was so high that it would shock the conscience of the court. So when a term is deemed unconscionable, then the court will refuse to enforce that term. Just like the example of the interest rate, if they deem that to be an unconscionable term, then they're going to impose a different, lower interest rate than the one that's deemed unconscionable. Now, the only time that the contract is usually deemed unenforceable or invalid is when the term is an essential term. So if it's an essential term, then the court either will rewrite the term or they'll void the contract. But if it's a material term, it's more likely that they'll void the contract than they are to rewrite the term. Reason being is with a essential material term, then the less likely there is to be a true meeting of the minds such that you can rewrite and find an acceptable alternative term. The implied covenant of good faith and fair dealing. Every contract contains this implied covenant of good faith and fair dealing. This means that every party is obligated to act in such a way that they do not hurt or harm the other party of the benefits of the agreement. So the painter, for example, with painting the home, he has an implied covenant of good faith and fair dealing. So if you take the example of going and buying paint, the homeowner may have paid money for a certain grade of paint, and the painter, that may be a high, expensive cost paint, and the painter may decide to go and get the cheapest form of paint that he can, and it may save him $30 a gallon. But he's being paid the extra money to cover that $30 extra per gallon. And so by him getting the cheap paint and using it to paint the home, he is, in my opinion, violating this implied covenant of good faith and fair dealing, because the party is being deprived of the benefit of the agreement being that he gets this good top of the line paint. So that's an example of where the implied covenant of good faith and fair dealing would be violated. So a couple of good points to live by to help you decide if you're violating this implied covenant of good faith and fair dealing is, as a company, would it embarrass you or the company if what you were doing was made public? Second, would you act the way you are if you were dealing with either a close friend or a family member? For the painter, they would probably tend to not buy the cheap paint and pocket $30 for each gallon that he bought if he was painting his mom's house. If he was painting his best friend's house, he would probably buy the good paint and not do what he's done to the homeowner in our scenario. Statute of frauds. We've talked about earlier how contracts can be in writing or they can be oral. Well, there are certain contracts that have to be in writing. At least some portion of the contract has to be in writing. And this is known as the statute of frauds. And the statute of frauds is a concept that requires that certain contracts be in writing. The statute of frauds is an affirmative defense. That means that it's a defense that has to be raised in order to invalidate a contract. So a court's not automatically going to look at a statute of frauds. It's not an element to go through and say to be we talked about the 4 requirements to be a binding contract. There's not a 5th one that's added in there of, does the statute of frauds apply, and if so, is the agreement in writing? That doesn't apply. If the contract is under statute of frauds has to be in writing, the contract will still be enforced if no party raises the statute of frauds as an affirmative defense. So if you don't object to the contract as not being in writing, then you are essentially waiving that right, and the contract will still be enforced against you, even though it may be under a statute of frauds defense an invalid contract. So here are the agreements that usually must be in writing. When you have a sell or lease of land, when you're selling land or you're leasing land, you've got to have that agreement in writing. If it's an agreement that can't be performed in 1 year, this is the one that becomes the hardest to know, because sometimes the agreement may be something that is believed that can be performed in 1 year, but as it later proves, it actually took longer than a year to perform. So those are probably of these ones, this is the one that's the hardest to know when you need to get it in writing as opposed to just an oral agreement. Prenuptial agreements, these are the agreements that you sign before marriage. Then lastly, an agreement to pay the debts of a third party. So if you're going to pay the debt of someone else, it has to be in writing. So when we talk about a contract, I said it just has to have some form of writing. It doesn't have to be a formal, drafted by a lawyer contract. The writing the writing requirement may be satisfied by just the mere communications that go between. It may be some sort of offer that's written in an email, and there may be a correspondence back accepting that. That could be sufficient to establish the statute of frauds and get you past that defense. The only requirement between the writings is that they require to have the essential terms. So you've got to have the subject matter, the price, the duration of the contract, form of payment, things like that that are material terms. You don't necessarily have to have written down um, that we agree to arbitration or we agree to a choice of law clause of Tennessee law. What you need to have is the essential terms, and that's what the statute of frauds requires to be in writing. So we've talked about making the contract. What happens when somebody doesn't perform under the contract? Well, then you have a breach of contract claim. So if a party doesn't meet their obligation under the contract, then the non-breaching party may sue the breaching party. So let's go back to our homeowner and painter. The homeowner agrees to pay him $2,000 for painting the home. The painter has finished painting the home, and after he's completed the home, the homeowner decides that he's not going to pay the $2,000. In that instance, then the homeowner is not meeting their obligation under the contract, and so the painter is the non-breaching party. They've complied with their promise and uh, obligations under the agreement. The painter is the non-breaching party. He's done what he's supposed to. The painter can then sue the homeowner, the breaching party. So a breach of contract claim, there's three requirements. In order to have a successful breach of contract claim, you've got to be able to prove these three things. You've got to prove that there's a valid contract. So all the things we talked about, you've got to have a valid contract. You got to think about statute of frauds defense. That can't apply if it's something that has to be in writing. It's got to be in writing. You've got to have a meeting of the minds. You've got to have consideration. You've got to have capacity, and you've got to have a legal purpose with the contract. So if you meet those requirements, you're going to have a valid contract. Then you've got to show that the party has materially breached the contract. So in this example here that we've talked about with our painter and our homeowner, the homeowner's breach is a material part of the agreement. The payment is what induced the painter to agree to the offer of painting the home. Without the $2,000 payment, the painter would not have agreed to paint the home. So that would be a breach of a material part of the contract. And lastly, the non-breaching party has to suffer damages. If there was a breach of a contract, but there was actually no damages, then you don't have any breach of contract claim. As we'll talk about briefly with the damages here at the end of this topic, the purpose of damages is to put you back in the same place you would have been if the contract had been performed. And if you don't have any damages, then you would be made better than you would have been had the contract been performed. And so if there's no damages from any mere technical breach, you're not going to have a breach of contract claim. You're not going to be entitled to profit from a person's breach. So an example of a case that I've had is you go back to this is the case that we've had over the promissory note of the building the home. So the bank was obligated to make the payments on a check that was payable to both the borrower and the construction company. The bank, if they had made the check payable to the construction company only, in that scenario, they would arguably be in breach of the contract. But what damages would they have from that mere breach? Although there's a technical breach of a valid contract, does the borrower have any damages? No, they didn't suffer any harm because the bank inadvertently or accidentally made the check payable only to the builder instead of to the builder and the borrower jointly. So in that instance, without any damages, she would not be able to prevail on a breach of contract claim. So the breach must be material, meaning that the party did not perform or abide by an essential term of the contract. So in our example, the material term of the contract and is that they pay the $2,000 upon completion of painting the home. Not paying that would be a material term because the party did not perform their obligation of paying under it. They didn't abide by that essential term of paying $2,000 when the work was done. So if the breach is material, then the non-breaching party is relieved of its obligations. So when we talked about modifying the contract to paint both the inside and the outside, let's go under that assumption. Under that agreement, the homeowner is going to pay the painter $2,000 for painting the inside and $2,000 for painting the outside. If the painter has finished painting the inside and requests $2,000 and the homeowner refuses to pay and is in breach of the agreement, the initial agreement, then at that point it would be a material breach and the painter would be relieved of his further obligations of painting the outside. But if the breach was a non-material breach, then the non-breaching party, the painter, would still have to perform under the contract. So if the breach was that the payment was supposed to be made in cash and the homeowner provides a money order, which is as good as cash, then that's not going to be a material breach of the terms. The painter is still being paid, and so in that instance, the painter would still be obligated to paint the outside of the home. But if it is more significant than that, and they could either choose to suspend their performance until the breach is cured, or they could sue for damages. So if you take the example of they couldn't pay for a week, and at that point they haven't breached their obligations fully because they're intending to pay and said they'll pay, but the painter is not going to be obligated to continue to pay. There is some events that can be unforeseeable, and these unforeseeable future events may make a contract unenforceable. So there are three types of unforeseeable events that come up that create the right to void a contract. One is impossibility, the other is impracticability, and lastly, frustration of purpose. So let's look at impossibility quickly. Impossibility means that the performance of some act may become impossible. So in this case, when the performance of an act is impossible, the court will not award any money damages for a breach. That is a failure to perform. So example here is Scott and Fred execute a contract for Scott to paint Fred's house for $1,000. Scott is in a bad car wreck, is in an induced coma at the hospital for an unknown duration. Well, I guess this is our example that I've been going off of, but let's say Scott's the homeowner and Fred is the painter. Well, no, Scott's the painter and Fred's the homeowner. So in this example, you've got Scott and Fred. Scott's in the car wreck. That was an unforeseeable event. It makes painting the home impossible because he's in an induced coma for an unknown length of time. He may not ever be able to paint the home again. This was an act that was, the car wreck was not foreseeable, wasn't planned when they made this contract. So in this instance, the court would likely find that Scott performing the contract is impossible, and therefore Fred would not be entitled to any money damages for Scott not performing his part of the contract. Impracticability is similar to impossibility, but it's something that's not as extreme. It's where performance is possible, but it's just commercially impractical, meaning that it could be done, but it's just going to be a lot more expensive or more difficult to accomplish. Impracticability is ones in which it's difficult to prove when that happens. When you really have commercial impractical scenario, it's difficult to pinpoint that, and courts just really don't apply this doctrine very often. The book gave the example of I think it was 1967, there were ships that were trying to deliver goods, but the Suez Canal was closed and they'd have to sail all the way around the tip of Africa. It could be done, but it was going to cost a lot more money and a lot more time. And they found that in those instances, performance was possible, but it was commercially impractical. Frustration of purpose. This is a doctrine that goes back to the old common law. So the frustration of purpose is where the parties can perform the contract, but under the circumstances that are existing then, which were different than the circumstances when the contract was made, that change in circumstances has resulted in the contract not having any value to either one or both parties. So to rely upon this defense, you've got to show that one, the stated purpose for making the contract is frustrated at no fault of the breaching party, and it was frustrated by an occurrence of an event, the non-occurrence of which was a basic assumption upon which the contract was made. So defense doesn't apply if the breaching party either contributed to the frustration or the event was foreseeable. So the example in the book is a case that's in virtually every contracts book that's probably taught in any law school, but it's where there's the agreement to rent the room for the sole purpose of viewing the king's coronation. At the time that the parties made that agreement, everybody thought the king's coronation would be happening, and the room was being rented for the sole purpose of that viewing. It wasn't foreseeable that the coronation would be canceled, but the coronation, as the time came for it, was canceled due to the king's sickness. So in that instance, you have where an event that wasn't foreseeable happened, and it frustrated the purpose of the contract. The purpose was to rent the room to watch the king's coronation. Well, the king's coronation didn't happen, so the purpose of the contract, the purpose of the rental agreement, was frustrated. If the agreement was not linked to the sole purpose of watching the coronation, then if it was canceled and that was going to be, they were renting the room and they were going to stay there, and they were spending the night and they just happened to be coming so they could go to the coronation and watch it, then, in that instance, they would be bound by renting the room. But since it was tied to this sole purpose, the changed circumstances of the coronation being canceled really frustrated the purpose of that contract. So we'll quickly go over some of these. How can a contract, when does it end? How is it terminated? When is it discharged, meaning that neither party is obligated under the contract anymore? Well, there are a number of ways that contracts can be terminated or discharged. Mutual performance. The contract ends when the obligations under the contract have been performed in full. Our painter and our home owner. The homeowner pays the $2,000. The painter paints the interior of the house. The obligations of the contract are over, and mutual performance has concluded that contract. So material breach, we talked about a party materially breaching a contract. The non-breaching party is relieved of their obligations. At that point, nobody is bound to continue with the contract, and the non-breaching party would be entitled to seek damages. So the example we used when we went over that of the painter starts painting the house, and when he's painted the inside of the house, he's entitled to $2,000, and then he's going to start painting the outside of the house for another $2,000. If the homeowner doesn't pay the $2,000, then that's a material breach, and the homeowner is relieved of having to paint the outside. At that point, his obligations under the contract have ceased, and the contract is done. Anticipatory repudiation. This is where one party knows in advance that the other party will breach the contract. So they tell you if the painter is painting the inside of the home and the homeowner tells him that he's not going to pay him because he lost his job, then the homeowner doesn't have to wait for that breach to happen. He doesn't have to keep painting the house to make sure that he's not going to pay him the $2,000. In that instance, the repudiation of Ptolemy can't do the act is considered to be a material breach, and it relieves the painter, here the non-breaching party, from having to wait and continue with his obligations until the breach occurs in the future. We talked about the conditions here, the condition precedent, condition subsequent. So if either it was conditioned upon occurrence of something or failure of something, it could terminate the agreement. Like the one we had on the condition precedent. It was the one where the one company was buying the book company that had a distribution side and a publishing side, and they only wanted the publishing side. They were that ABC company had an agreement with another booking company that did do distribution, and that company was going to buy the distribution contingent upon the ABC company buying the other company. And so if the ABC company does not buy the second company, then the obligations that the Book Pro had with ABC, that those obligations and that contract are at that point concluded. They're terminated. A contract is also discharged by mutual rescission. That's where both parties agree to terminate the contract. So if the painter and homeowner, if the homeowner does in fact lose his job before the painter begins painting, and he goes to the painter and says, I've lost my job, I need to not have you paint the house, I need to cancel this contract, and the painter says, no problem, I'm too busy anyway, no big deal, then in that scenario, both parties walk away and have agreed to terminate the contract, and there's no longer any obligations under the contract. Contract can also be terminated by operation of law. So we go back to those impossibility, frustration of purpose, and practicability. In those scenarios, if a contract was found to be impossible to perform, then the contract is terminated by law, and you would have no continuing obligations once it's terminated. Another example of when a contract can be terminated by law is in the instance of a minor. If the minor contracts with something, the minor has, under the law, the ability to void it. That would be an example of where the law would allow the contract to be voided, and there's no longer any continuing obligations on either party under the contract. The book has a short section on liability releases and waivers. These are those agreements that you get when you go to in Jackson. I know there's the example of Sky Zone. That's the indoor trampoline park where I go in there, and as a lawyer, you start looking and you're thinking, man, there's a lot of places in here for people to fall and get hurt. And you just see a lot of legal liability risk where people could get injured of, breaking an arm, twisting an ankle, hurting and tearing something in their knee. Just opportunities for that. And as you come in, one of the first things they have you do before they let you go out and jump is you execute a release or waiver of liability. And that's where it's an agreement that essentially you agree to not hold Sky Zone responsible for any injuries or other liability that could result from you jumping on the trampolines there. So these rise in usually dangerous activities, whitewater rafting, skydiving would have them, paintballing has them, things like that. And so you just say, essentially you are assuming the risk, saying that if I get hurt, it's my fault, and I will not hold you as the proprietor or property owner or whatever business liable for my injuries. So liability releases and waivers are generally effective. So they're usually enforceable agreements that are entered into between the parties. Their Sky Zone's letting you jump and use their facilities for 30 minutes, an hour, however long. You're paying some money to do that, and this agreement's being executed as part of that. This is a valid binding thing. Waivers, however, are not effective for gross negligence or intentional or willful misconduct. So for really egregious things, you cannot contract that away. But uh, waivers on behalf of minors are unenforceable. And it's very clear in Tennessee since I think the 80s, that's been the rule. Sometime in the 1980s, the case came out that said that you can't waive the legal rights of a minor. And so all those contracts, that waivers that they have you execute at Sky Zone when you go to jump there, and you're doing it for, I got a 6-year-old and a 5-year-old, and they like to go there. And every time we got to execute those waivers, and every time I keep thinking, okay, we'll execute these for the kids, but if they get hurt, they're not, binding on us. We haven't waived any right because under Tennessee law, I cannot waive liability for a minor. So they would retain their rights under that contract, and that's an example of a contract that Tennessee has deemed to be against public policy. In the state, it's deemed to be against the public policy to allow a minor to waive his or her right in these agreements. So the last topic, let's briefly cover remedies. So we've talked about how a contract's formed. We've talked about how it can be modified, or some of the things that can happen with it, especially when you have a breach, and what some of your times that you're entitled to walk away from agreements. Well, what happens when there is the contract formed and someone breaches it? We've got the contract of the homeowner and the painter. They've got the agreement. Let's go with the one in which they're going to paint the outside for $2,000 and the inside for $2,000, and so the homeowners agree to it. The painter has come in, they've painted the interior, they're requested their $2,000. They're going to move to the exterior, and that's when the homeowner says, "I'm not paying you the $2,000 for the interior." He's breached the agreement. Well, what would happen? What can they get? They can get the monetary damages. Sometimes courts will also award equitable remedies, such as injunctive relief or specific performance. Those are under very limited, narrow circumstances. The general remedy for a breach of contract is just monetary damages. So the purpose of monetary damages is to place the non-breaching party in the same position that he would have been in if the contract had been performed. So in our example that we've talked about, you could see it's very easy to put the painter in the position that he would have been in if the contract had been performed. In the example here, he would have been, if the contract had been performed, he would have gotten $4,000. But is that what he really gets now? The answer would be no, because the purpose is to put the non-breaching party in the same position that he would have been in had the contract been performed. Well, but he also can't profit from it. So in this instance, he would only be entitled to $2,000 because he's not performed any work to be entitled to the $2,000 for painting the exterior of the home. So in that scenario of giving him the full recovery as if the entire contract had been performed, you would have a scenario in which he profited. And so the courts would likely limit his award under the purpose of monetary damages to only $2,000. Punitive damages, we'll talk a little more about those when we cover negligence and other tort principles. But punitive damages are usually, and I think we talked briefly about them in the constitutional law topic, but they're meant to be a deterrent. They're meant to provide set an example and to discourage that conduct in the future. Now, monetary damages are meant to also have a deterrent effect, but they're really not meant to have the deterrent effect that punitive damages have. Compensatory damages monetary damages are meant to make you whole in the sense that you'd be put in the same position you would have been in had the contract been performed. And implicit in that, and putting you in the same position if the contract had been performed is that it should deter you from having similar conduct in the future. By similar conduct in the future, we're talking about conduct breaching the agreement, because you don't want to have to pay uh, the money to somebody for your breach. But punitive damages are vastly different, and that their specific purpose is punitive in nature, and they are meant to be uh, punishment more than they are and a deterrent more than they are meant to compensate anybody for anything like monetary damages. But anyway, in the breach of contract cases, punitive damages are usually not a remedy that can be awarded. Mitigation. This is a big factor under um, under these contracts and things. You have a duty to mitigate your damages. Um, so the non-breaching party has a duty to try to lessen their damages, make it so that their damages are um, as small as they can be. You got to take reasonable steps. So let's say you've got, we'll talk about this in future weeks, but an employment agreement, and it's let's say it's a hospital, and it's a certified nurse anesthetist, so they make good money, and healthcare is a good field because it's one that is easy to get another job in. So if the CRNA has a agreement with the hospital, and the hospital terminates her, and she sues for a breach of contract, then she has a duty to try to limit her damages. She may be able to try to sit there and it takes 2 years to get to trial and say, I haven't found employment. It's been tough. I can't find anything. I've been looking. Well, she sat there for 2 years. As a CRNA, she should be able to find a job within a few months at the longest. And so in that scenario, her failure to take reasonable steps to find another job would be a failure to mitigate her damages, and it would result in her award being reduced. And so she would get less money. Um, if she made $100,000 a year, to use easy numbers, and she was off for 2 years, she's not going to get $200,000. She will probably get significantly less than that because if she had taken efforts and reasonable steps, she could have mitigated her damages and gotten another job. Now, she may have gotten a job making $80,000 a year. In that instance, she'd only be entitled to $40,000 plus whatever she missed for the time that she was off work. So this is where the non-breaching party can get in trouble. So when you um, are the party who's not done anything wrong under the contract, you have the duty to mitigate damages. You can't sit idly by and allow your damages to keep piling up. The court's not going to allow you to recover an excessive amount because of your lack of effort to stop the bleeding, so to speak. So the non-breaching party has to take steps to do what they can to mitigate their loss. Specific performance. This is an alternative to monetary damages. A court may award specific performance. Um, Specific performance is a very rare remedy. Um, it can apply to any of these three scenarios, but I'll tell you that there's really only one scenario that it applies to with any regularity. So you could have a court order specific performance when goods are sold as unique. Maybe you could have some really unique goods or like antiques or something like that, in which it's a rare antique and it's one of a kind that can't be found elsewhere or bought on an open market or whatever. Um, it can also be awarded in the sale of land. Land is considered to be very unique and the sense that you can't find two pieces of property that are the same. You can't find a piece of property that sits uh, with the same, amount of trees and the same pond on it, or up against the river in the same spot. So land is considered to be very unique and something that is subject to specific performance. So if you have an agreement to sell land and they decide they don't want to sell land, they'll just try to pay some monetary damages for their breach. That's probably one you're going to lose on because the court's probably going to order you to perform with the contract, and by requiring specific performance, they're going to require that you actually sell the property, and you're going to have to complete the contract that you agreed to. Lastly, specific performance may be awarded when the amount of the loss is too uncertain, is too speculative, such that you cannot calculate fairly the monetary damages. So that's the point, in that you can't put a dollar value on it, and so if you can't quantify the loss to money damages, then you should be required to perform the contract, so that way the non-breaching parties put in the position they would have been if the contract had been performed. The goods sold are unique and the amount of losses too uncertain such that it can't be fairly calculated. Those don't come up very often. The one that comes up with any sort of regularity, if at all, is the specific performance for sale of land. Injunctive relief, this is the last form of equitable relief. Again, this is where court orders some conduct by the parties. It's rare for that to happen. A court may award a party to perform an act, and so it's possible that they may order them to perform something. But again, that gets really close to specific performance, but it's rare.